resource persons. This question is from Ms. Kiran. She's a lawyer based in New Delhi. Thank you, Professor Deplano, for those insights on the work of the WG on SR. I was wondering if there is anything mentioned in its TOR that stops the WG from recommending anything that goes beyond the Outer Space Treaty stipulations on space resources. So I think this question is addressed to Professor Rosanna Diplan.
Yes, thank you very much for the very interesting question. I have here with me the terms of reference of the working group. So the short answer is that no, there is no reference in terms of content or boundaries of the discussion. So technically, the working group can go well beyond the boundaries of the Outer Space Treaty or remain well within those established principles. Probably my remarks were trying to assess the political opportunity and the normative repercussions of probably going beyond the Outer Space Treaty. Here there is a historical precedent, and in particular I have in mind the negotiations of the Moon Agreement. We know that if we stretch too much those principles and in general provisions of the Outer Space Treaty in order to encompass concepts which are taken in themselves very valuable and also opposite to consider in context of space resource utilization, such as the concept of common heritage of mankind, the idea of property rights in outer space or only on space resources. Those principles are those most at risk of not being supported by widespread support by states. And if that is the case, and those principles are reflected in a resolution of the General Assembly, which is a simple recommendation, it's not a legally binding instrument, the risk is that we will just have a repeat of the history of the Moon Agreement. So some states will be very supportive of those principles, and in no likelihood, the spacefaring states or those developing, even from a commercial perspective, the capability now of exploiting the vast resources of outer space will try to be a little bit more conservative and stick to those principles, broad, open, flexible, that we have already in the Outer Space Treaty. So it's just a risk. We have a historical precedent in general, according to the findings of my research, resolutions of the General Assembly, which are not very well supported by a conspicuous number of states, bear the risk of becoming a moral, a political source of obligation, but not legal source of obligation.
I did want to just add one point here. Yeah, that was, I think, an insightful assessment of that. One thing that did come out of the Moon Agreement negotiations, although the Moon Agreement really does not have universal application, although it's technically enforced, there are no space powers that have ratified it. But in the Moon Agreement itself, there was a very interesting interpretation regarding space resources that is still at play today in different ways. And that is that resources in place are at least understood universally to be under the common province of humankind, right? Maybe not the common heritage of mankind, CHM designation, that's a little more controversial, but at the very least under the idea of the common province of humankind, which is part of the Outer Space Treaty, you know, the Magna Carta, the founding treaty, the Outer Space Treaty itself of 1967. However, resources once removed are something else. So that is that in place, they're under a common province designation as understood. But once you remove those resources, there is the thought that then those resources can be, that you can't claim property rights over those resources. Now, there's a couple interesting precedences for that. Both the Soviet Union, Russia, and the United States returned lunar samples, and they are owned by the governments. I mean, in the United States, in fact, there was a case, an interesting legal case, where two folks at the lunar samples are in a vault at the Johnson Space Center. There were two folks that illegally took lunar samples, and they were prosecuted for the theft of government property. So we've claimed property resources over extraterrestrial resources that have been removed from their in situ location. The other interesting development, I think, as well, is sometimes it's called the Asteroid Utilization Act, passed in the United States. Officially, it's the Space Resource Commercial Exploration and Utilization Act, passed by the US Congress, signed into law by the US President, which does allow for property rights, even commercial property rights, over resources that in the future could conceivably be removed from asteroids. So I think there's some interesting developments here at place, although we talk about non-appropriation or property rights, common province. I think there's some interesting precedences and interpretations here that come out of the Outer Space Treaty regime that have allowed for this kind of property rights to emerge in regard to resources removed from their in situ location extraterrestrially.
I can also join in, if I may, by way of advertising. I literally wrote a book on this very subject about 10 years ago. And rather than waste your time now, I invite you to buy a copy. I don't actually care if you read it or not, but I certainly invite you to buy it. My care factor ends at the point where you buy it. And you can buy it online, or you can also buy it cheaper from the trunk of my car. As I trawl copies of it in this book when I travel around India in the next 3 weeks.
Thank you so much, all the resource persons, for responding to the question. We have one more question for Dr. Ricky Lee. The question is, if Indian astronauts are set for space exploration and the space shuttle face some technical problem and they eject, land in some other country, what is the procedure to bring them back to homeland, and which law will be applied, Indian law or the host country law?
Definitely the host country law. The rescue agreement is going to bind whichever state that they land in to send them back to India. They are supposed to send them back immediately, but how they interpret immediately in the context of practical difficulties can pose some interesting questions. But that's not to say that there is going to be quite a bit of mucking about. Yes, there will be some mucking about, but they will come home. They will come home in a reasonable time frame. And most states that have cause to deal with the rescue agreement have usually complied with their obligations without much prompting. There was about 15, 20 years ago, there was a discarded engine from a Delta III rocket that was launched from the United States and somehow landed on a beach in South Africa. And a local beachgoer found it, picked it up, put it on the back of his truck, amazingly, given how heavy it would be, and donated it to a local museum. The local museum was very grateful for having a piece of space junk to exhibit, and people started coming to the museum to check out the space junk. The South African government found out about it and insisted on taking possession of the engine to return it to the United States. Even though it's a spent engine, they probably don't need it back, but they recognize that they have an obligation under the rescue agreement to send it back. There's no South African legislation itself to send it back, but they insisted on it anyway. As a side anecdote, the museum reacted by building a new room to their museum to house this engine part and make sure that the doors and the windows are smaller than the engine. The South African federal government reacted by bulldozing that building, taking the engine and sending it back to the States. So I would say that's a roundabout way of saying, yes, the host country's laws will apply, but you're going to find that they're going to comply more to the letter and the spirit of the rescue agreement than one may usually expect, regardless of what the relationship between the two countries may be.
Thank you so much, sir, for your enlightening response. Now we move to the last question for this session. If you have further questions, they may be addressed in the next session. So this question is from Vamsi. The question says, What would be the reforms in case of space loss if humans got in contact to any extraterrestrial intelligence? It's very evident by this time that life can be supported in many other planets.
Go first. I wrote about this subject. I'm not going to, sell a book about this. Don't worry. The quick answer will be no. I don't anticipate our laws to be changed, and that's not because I consider contact with extraterrestrial unlikely, which I do. I do consider it unlikely. But even if they do, they don't get to change our laws. Just as much as we don't usually let outside influences to decide our domestic laws from being changed. I mean, Australians, for example, don't let any country change our laws unless it's the United States, in which case we do whatever they want. But we don't usually allow external influences to dictate what our laws and how they should react. I don't see how international treaties would change just because we make contact with extraterrestrials, even if they are more advanced than us, even if they are hostile, even if they are, because quite frankly, if they're hostile and they're more intelligent than us, then self-interest of states that want to A, survive, and B, take advantage of any new technology that might come to them is going to prevent any international agreement towards development of international law anyway. But also to go back to the point, there have been proposals for guidelines on an international level as to how should the United Nations and as well as the international community as a whole deal with the prospect of extraterrestrial contact during the height of funding and activity under the SETI program. SETI is the Search for Extraterrestrial Intelligence. And there were actually draft guidelines that were proposed. Most of it just involves, well, if you make contact with extraterrestrial, you have to tell the Secretary General of the United Nations, and then we shall talk about it in the General Assembly. Now, the General Assembly only sits from September to December. If you remember from the movie Independence Day, it only took about a day to destroy all of our major cities and about 3 days to wipe out all the minor cities. And it only takes 4 days for us to fight back for a resounding victory against whatever advanced technology the ETs may bring to us. So we don't really have time to change the laws. We just bring the fight on, I say.
Can I just also add as well that we do have under the UN a ambassador that we would turn to who would deal with any intelligent extraterrestrial that might try and make contact with us. I think Mazlan Osman is still the ambassador. She may not be anymore, but the other thing as well is I would just say the extraterrestrial intelligence, I would ask maybe just to, definition of terms, because of course there's microorganisms in space and they live in space, and sometimes, they attach themselves to spacecraft suit and they come back and they're intelligent because they survive. It's I can see Ricky laughing at me, and I do have Ricky's book. It's very good. I suggest you all have a read through it. But just to add to that anyway, that we would probably hope that our ambassador for alien contact would be able to at least extend some sort of bridge to communication anyway.